whole truth, nothing but the truth, so help you God?
I do.
All right, you can put your hand down, sir. Mr. Boileau, I'm going to ask some questions to make sure that you're making the decision to become a witness freely and voluntarily, okay, with a full understanding of your rights, okay? Do you understand that you have a constitutional right to remain silent?
I do.
Do you understand that if you were to choose to remain silent and not become a witness, I would instruct this jury that the fact that you testify cannot be used against you in any way, and that a jury is not permitted to draw from that any inference of guilt whatsoever?
I do.
Do you understand that if you testify, I will instruct the jury that they have to consider your testimony like that of any other witness? Do you understand?
I do.
You understand that if you testify, you will be subject to cross-examination by the state?
I do.
Now, I don't believe this applies to you, but if you had ever been previously convicted of a felony or a misdemeanor crime of dishonesty, you could be impeached with that. Do you understand?
I do.
Okay, state, I assume he has no prior convictions of any type.
No, Your Honor.
All right. Now, do you understand that the right to remain silent and the right to testify is a right that belongs solely to you?
I do.
It does not belong to anyone else, including your attorney. Do you understand?
I do.
Now, I expect that Mr. Taddy has given you his advice and his opinion. I don't want to know what you've talked about, but have you had the chance to talk to him about this decision?
Yes.
Has he given you his advice and his opinion?
Yes.
You understand that no matter how strong his opinion may be, one way or the other about what is in your best interest, ultimately the decision whether to testify or remain silent rests solely with you.
I understand.
Okay, and have you discussed all of this with Mr. Taddy?
Yes.
Do you need any additional time to speak with him about this?
No.
Do you wish to become a witness in the case, or do you wish to remain silent?
I wish to become a witness.
Do you feel that you have been adequately prepared for testifying?
Yes.
Are you making this decision voluntarily?
Yes.
Has anybody forced you, coerced you, pressured, or threatened you to get you to make this decision?
No.
I will find that Mr. Boileau has waived his Fifth Amendment privilege against testifying freely and voluntarily, and knowingly and intelligently. With that being said, are there any other witnesses that you want your attorney to call during the trial?
No.
Do you have any questions for me? Is there anything that you want to bring to my attention?
No.
Are you satisfied up till this point with Mr. Taddy's services for you?
Yes.
Has anybody told you how to answer my questions here today?
No.
All right, very good. All right. We're going here shortly. Okay, I've been told all the jurors are here. Y'all want to take 5 minutes until 8:30? I'm not sure if anybody else is planning to be in attendance, but family-wise,
Yes, Your Honor,
for the
if you
state,
don't mind.
yeah, for the state or defense, if people are milling about, we'll give them 5 minutes. So, we'll be back in 5 minutes. We'll bring in the jury.
Yes, Your Honor.
Anything else we need to bring up before that?
No, sir.
Okay. Defense?
Yes, sir.
Okay. Ms. Freeman? Jurors are getting rounded up. I did want to thank everybody in the audience for your appropriate in-court behavior yesterday. I don't know that I've ever been part of a trial where there have been this many people, all of whom have been appropriate. So, thank you. Council, y'all can be seated. First, good morning, welcome back. When we separated yesterday, I instructed all of you to not try to investigate or learn about the case, including the use of electronic devices, to not watch any news media or engage in social media use or anything like that. Have all of you been able to follow those instructions?
Yes.
Did anybody happen to, in the course of the night, come across any information about this case on the internet or otherwise? If so, raise your hands. Thank you for following my instructions. All right, very good. We'll go ahead and proceed then. Mr. Taddy, you can call your first witness.
The defense would call Leslie Dale Boileau Jr.
Come on up, sir. I do. Be seated.
May it please the court?
Yes, sir.
Counsel. All right, would you state your full name, please?
Leslie Dale Boileau Jr.,
How old are you, Dale?
33.
Are you employed right now?
I am. I'm
What are you doing for a living?
working at a fabrication shop learning how to weld.
And you used to work for the Marion County Sheriff's Office, is that
I did.
right? How long did you work for the sheriff?
8 years.
And you were terminated as a result of the incident that we're here about today.
I was.
What were your duties at the time that you left the sheriff's office?
I was a patrol deputy.
How much did you weigh in September of 2024?
210, 215 pounds.
Okay. So it looks like you've lost a considerable amount of weight.
A little bit.
Okay. How tall are you?
5'6".
In September of 2024, how long had you lived in the house on 32nd Avenue?
About 5 years.
Did you own it or rent it?
I had a mortgage.
How did you meet Polina Wright?
We initially met on a dating app, and then we eventually met in person downtown a couple weeks after.
How did the first meeting go?
Went well.
Did you begin to see each other at that point?
Yeah.
At the time of her death, how long had you been dating Polina?
About 2 years.
Tell us about her.
She was a great person. She was modest. She was respectful. She was loyal. She encouraged me to be a better person. She was just naturally beautiful.
Had you met her parents?
I did.
How often would you see her parents?
Every now and then.
Did they live in Marion County?
No, they didn't.
Where did they live?
I believe it's Citrus County, Florida City.
Did you have some knowledge of Paulina's upbringing?
Yeah, she told me.
What did she tell you?
She went basically through her entire childhood. We both did. She was adopted from Russia when she was 6 or 7. She has a twin sister and a brother that was adopted with her.
So the Wrights adopted her
Yeah,
from Russia.
yeah.
Did she have other siblings within the Wright family?
Yeah, she did.
Was she working in September of 2024?
She was.
What was she do? What did she do for a living?
She worked as basically, I would say, a secretary for a company out in the shore. She did their billing and purchasing and payroll and stuff like that. She was working on, actually in September, transferring over to a new job.
Do you know if she'd been to college?
I believe so, yes.
Did she have any kind of degree that you were aware of?
I believe she had an AA degree from CF.
And you said you'd been together for 2 years. Had you begun to discuss marriage at all?
We kind of joked about it, but it was obviously on the table. We were working towards that. You don't date someone for 2 years and not have that on the table, basically.
What were your living arrangements by September of 2024?
she was free to come and go as she pleased. She was still in her lease at an apartment complex, but we were actively speaking on, and it was going to be like in 3 or 4 months when her lease was up, she was going to be living with me full time.
Did she have a key to your house?
She did.
Let's talk about September 19th. What did you do that day?
We met up probably around 9 or 10 o'clock that morning.
How did you meet up?
She came over to my house.
Okay.
It was pretty standard. I was going into my long weekend of work, so pretty much any day we had off before that, we try to hang out. So it was a pretty typical day for us. We went out to lunch, hit a couple stores, and then was just hanging out around the house.
Where did you go to lunch?
Longhorn Steakhouse.
Was any alcohol consumed at lunch?
No.
Where did you go after lunch?
If I remember correctly, we went to Target and I think TJ Maxx, and then we came home.
And what did you do when you got home?
We just hung out, just watched TV.
All right. At some point that late afternoon or evening, did you decide to go out to dinner?
We did.
How did you choose the Mexican place?
We talked about a couple different options, and we landed on Mexican food. It was extremely close to the house, and we didn't really want to.
Had you been there before?
Yeah.
So you ordered food and margaritas.
Yes.
Okay. Tell us about the drinks.
Well, we normally get one margarita when we're there, because it's a large margarita. But it was 2 for 1s that night when we walked in, so and they were taking a while. We were there over an hour, so we just started ordering the 2 for 1 margaritas, and we landed on 3 by the time we were done.
How were they serving them?
And like little mug gauntlet things.
Okay. And 6 of them cost you $26.94. Is that right?
Yeah.
So that was less than $4.50 each.
Sounds about right.
Did they taste like they had any alcohol in them?
They taste a lot like sour mix, but
Okay. Now, the check that Detective Kern was able to obtain said your tab was opened at about 7:30 and then closed at 8:32 p.m. What did you do when you left the restaurant?
we drove straight home.
How far from the house is the restaurant?
5 minutes, easy.
Okay. And what did the two of you do when you got back home?
We changed. I don't really know what she was doing. She was doing her stuff, taking care of her cat. I fed my dog. That's when I came out to the living room and put on the football game and started doing the gun stuff.
Okay. Now, you changed out of whatever you had worn to the restaurant
Correct.
into the clothing that we've seen on the videos?
Correct.
Okay. And Polina had a blanket on
Yeah.
and nothing else.
Correct.
Was that normal?
At this point in the relationship, yes.
Okay. So that was typical for her once she got home and got comfortable, was to disrobe and grab a blanket.
I wouldn't say 100% of the time, but it was very common.
Okay. Did you have any more alcohol when you got back home?
No.
Now, you called 911 at 10:52 p.m.
Yes.
I'd like you to walk us through that 2.5 hour period of time from the point you got back from dinner until that call was made.
So when I came in and sat down at the dining room table, I started cleaning my rifle because I had just shot it a couple weeks prior, or within a week. I was waiting for all of my gun cleaning stuff to come in to clean that said gun. It was already all on the table. I saw it, I sat down and I started cleaning it. She was off doing other stuff in the house. And then she eventually came over and sat down, started talking to me. We weren't necessarily talking about the gun stuff, we were just hanging out. We talked about what we were gonna do next week, like, went through a bunch of different stuff, and then she started to show interest in the gun cleaning, so I started showing her parts, handing it to her, stuff like that.
Now, is this exclusively the rifle that
Yes.
we're talking about at this point?
Yes, it was just the rifle.
Now, and we'll kind of come back to exactly what you did with the gun stuff.
Okay.
But did the two of you stay at that table the entire 2.5 hours?
No, we were up and down.
Okay. So you would get up from the table, walk some other part of the house?
Yeah, I had to use the bathroom at some point, I remember. I know she got up and went to the bathroom at some point.
Did she get up from the table?
Yeah,
Do you know what she was doing when she left?
no,
Okay. So this wasn't a continuous, let's take apart and put together this rifle.
no.
Dale, have you thought about what happened that night and the mistakes that you made
Plenty,
every day?
pretty much.
What should have been different?
We shouldn't have been sitting across from each other.
Why didn't you move her?
I thought we were being safe. It was our normal spots to sit.
At a gun range during firearms training, how are trainees and the officers that go to do their annuals, how are they positioned?
In a straight line.
Okay. So nobody facing each other.
No, you're facing the target you're going to shoot at.
How many times have you gone through well, there's an initial firearms training, right, when you become a law enforcement
Yeah.
officer? Okay. And then you have regular training, is that right?
Yeah, once a year.
This is State's Exhibit 24. According to the state, this is a record of your training, including your firearms training. So in 8 years, you accumulated quite a bit of paper.
Yeah.
How many times do you think you'd been on a gun range while you were with the sheriff's office?
Maybe 12 times.
Okay. Had you ever been shaded by another shooter during those trainings?
Yes.
What does shaded mean?
Basically, flagged is another term for it. It means another officer on the range basically turns and points their gun at you.
So accidents happen.
They do.
Now, when you were talking with Detective Kern, you used the phrase dry fire exercise.
Yes.
Is that an accurate description of what you were showing Polina?
Yes.
Tell us what a dry fire exercise is and tell us that you have had to do one.
Yes, it's basically the first step to learning how to handle a firearm. It's the first thing you do in the police academy. It's really the only training and or teaching you can do inside of a house. It's basically just showing you how to hold the gun and pull the trigger.
Does it involve the sight picture
Yeah.
on a handgun or a rifle?
Yeah.
Okay. Now, did you show that to her and explain it to her
Yes.
with that rifle?
Yes.
Did you give her something to aim at?
Yes.
What did you tell her?
The picture on the wall.
Where was the picture?
A couple feet next to me.
Okay. Behind you and
Yeah.
away from you.
Yeah.
You didn't ask her to point the rifle at you.
No.
And you never pointed the rifle at her.
No.
And you weren't playing cops and robbers with guns.
No.
What did she think of the rifle?
She didn't really care for it. It was too heavy.
All right. So when she was done with the rifle, what happened?
I put it back together and I laid it on the end of the table. And that's when she picked up my handgun.
Where was the handgun?
It was just laying on the table.
Is that the gun that goes with your uniform or another gun?
It's my off-duty weapon that the sheriff's office gives us to carry.
Tell us what happened when she picked up the handgun.
Well, when I was laying down the rifle, I look up and she's holding the handgun. And obviously I knew that gun was loaded because it's the one I took to dinner. So I asked her to hand it to me, which she did, and I unloaded it and then I handed it back to her.
And how did you unload it?
Taking the magazine out and ejecting the one that's in the chamber.
And where did you put the magazine and the round you ejected?
I just set it on the table.
On your side?
Yeah. Well, I was on that side of the table at that point.
Okay. Now, when you handed her the rifle, did you hand her the weapon loaded?
No.
Did she ever have the ammunition for the rifle?
No.
When you handed her the handgun, was there any ammunition with it?
No.
So that both of them were safe when you handed them to her?
Yes.
Okay. What did you do with, what did she do, and what did you show her to do with the handgun?
Well, I demonstrated first how to hold the handgun. I pointed it at the wall, like to the right of her, where the chalkboard was. Showed her how to hold it, showed her how to pull the trigger. Showed her how to work the action of the handgun, and then I handed it back to her.
Okay. Now, was all this going on because you wanted to teach her how to handle a handgun, or did she ask you to do this?
She was inquisitive. I had mentioned to her in the past that she needed to learn home defense, basically. I was like, I'd pay for a class, like I'd go with you. She made it sound like she had never touched a gun before, so I was like, there's always guns around my house because of my job, so I was like, you need to learn that type of stuff. She always kind of put it off, didn't really show any interest until that night.
Now, you've already said other things were going on while this exercise was playing out. Was the television on?
Yeah, we were watching football.
Okay. So this was a Thursday night?
Yeah.
So it was the NFL game?
Yeah.
Okay. And from where you were seated, could you see the television?
Yeah.
Okay. But you had to turn to see it?
Yeah, I was kind of angled, the exact angle I'm sitting now.
How did the rifle end up back in your hands?
I remembered I didn't do a function test on it when I put it back together. I was allowing her to kind of do her thing with the handgun. I didn't want to overwhelm her. So we were just sitting there talking, and I was watching the football game.
Okay. And when you picked the rifle up, it had a magazine in it. Did it not?
Yes.
Because that's the way you had put it down.
Yeah.
Because when you put it down, did you intend to be done with it the first time? So how do you put up that weapon when it's clean and you're going to put it away?
I just put a magazine in it. I don't charge it. That's how we keep our rifles at the sheriff's office. We don't keep one in the chamber. And I typically just go store it.
And charge, what is that?
It means round in the chamber.
Okay. Does an AR style rifle have a different sort of way to load around?
Yes.
Explain it.
It has a charging handle where a handgun has a slide. Very similar, I guess, action you could say, but
All right.
different at the same time.
So when you had put the rifle down on the table, there was no bullet in the chamber,
Correct.
and it had a full magazine.
I don't keep, the magazine can hold 30 rounds. I don't
So
keep
you're
30.
5 short.
Yeah, I don't keep it fully loaded.
And that's to preserve the spring in
Yes.
the magazine?
Yeah.
Okay. So you had 25 rounds in it?
Yes.
All right. And when you picked it back up, while she's doing the dry fire thing with the handgun, how did you hold it?
I picked it up while watching the TV, and I was holding it like this.
Stand up, make sure all the
I was holding it like
see it.
this.
So you were kind of cradled.
Yeah.
So the magazine was down. Okay. And what was your intention? What were you going to do with it?
I was trying.
What is this function test you're talking about?
So when you disassemble a rifle and you put it back together, you have to do a function test to ensure that you put it back together correctly. If you didn't put it back together correctly, it's not going to fire the next time you need it to fire.
All right. And describe or explain the steps in this function test.
The bolt's forward, obviously. You have to pull the trigger and hold the trigger and then charge it. Release the trigger and pull the trigger again. And you're listening for the hammer to drop on the firearm to make sure you assembled it correctly. Because if you did not assemble it correctly, it's not going to make that click sound.
So you got it cradled in your arms,
Yeah.
barrel off to your left.
Yeah.
Okay. You're sitting across the table, and you're kind of watching TV. And you said you're listening for a click. So did you either put your head down to the rifle or bring the rifle up to your head?
Both. Like, it was because I was listening more so for a sound, and you can't really see what you're looking for type of deal. It's internal.
Okay. So you have to listen for it.
Yeah.
When you pulled the trigger the first time, what happened?
What was supposed to happen? You heard a click.
And then when you charged it and pulled the trigger the second time,
That's when it went off.
I know you know now where the barrel is pointing. Were you looking at Polina when you were doing this?
No, I was looking at the TV.
What did you do after you realized she was hit?
Called 911.
Did you go to her?
I did.
Now, what position did she start in? I mean, she's hit. Did she fall back, fall forward?
She was just sitting in the chair.
And did you maintain that position until the officers arrived?
Yeah.
So you were kind of cradling her head?
I didn't know what else to do.
Okay. Were you panicked at that point?
Yeah, I was freaking out.
So they got you out of the house. They told you to leave the house. Is that right? Had you seen the body camera videos before this trial began?
No.
You remember doing the things that you saw yourself do on the video?
No, but I don't know.
The screaming, and rolling on the ground, and all of that. Do you remember it?
Not
Any
really.
of that happened?
Not really.
Do you remember all the things you said to the police officers there in your yard?
No.
What was going through your head at that point?
I was just trying to figure out what happened, how I allowed it to happen.
And technically, Polina is dead because you ended up pointing the barrel at her.
Yeah.
But you didn't aim it at her.
No.
Did you ever aim it at her? So when you told the officers we were pointing the guns at each other, what did that mean when it came out of your mouth?
I was coming to terms with what happened. We obviously pointing guns at each other. That's how this probably happened.
Did any of them ask you what that meant? To describe exactly what had happened?
No.
Then you got driven to the police station, and they stuck you in an interview that I gathered from seeing the blanket was a little cold.
It was.
How cold?
I was shivering.
Do you remember how long you sat in that room?
No.
Was the sun up when you left that building?
Yeah.
You got there at midnight. Did you know that? You knew Sergeant Kerr, right?
I did.
How did you know him?
Through passing through the jail. He used to work for the sheriff's office.
He knew your name?
Yeah.
He knew you preferred to be called Dale?
Yeah.
Instead of Leslie?
Yeah.
And the jury's seen your dialogue with Detective Kern. Did he ever ask you the detail that I had asked you?
No.
I don't have any other questions.
State any cross-examination?
Yes, Your Honor. Mr. Taddy, is this your pen? I want to clarify a couple things that you just told us. So just to make sure, throughout most of the entire night, that AR rifle was in your possession.
Correct.
And when that gun went off, that AR rifle was in your control.
Yes.
You didn't slip. You didn't slip and fall, correct?
No.
You didn't drop the gun. You didn't drop the gun.
No.
You didn't misplace the gun or anything like that.
No.
In fact, when the gun went off, it was in your hands.
It was.
And when the gun went off, you were the one who pulled the trigger.
I was.
And when the gun went off, you were the one who intended to pull the trigger at that point in time.
Yes.
And the only reason why those firearms were out at that point in time was because you decided you wanted to clean them that evening.
I did.
And now, your AR, do you normally keep that in a gun safe at your house, or do you keep that out?
I keep it in my bedroom.
Okay. But you were the one who decided to take it out and bring it into the living room, or into the dining room.
It was already sitting on the dining
So
room
you
table.
put it there earlier,
Yeah.
and you decided to take out those cleaning products from Amazon,
Yes.
and you decided to clean the gun.
I did.
And in fact, you told us originally Paulina wasn't even anywhere near you when you cleaned that gun.
Correct.
But she later came over and she wanted to learn about the firearm.
She did.
And you decided to teach her about the firearm.
Yes.
And you decided to teach her about that firearm with loaded magazines and live ammunition sitting on that dining room table.
Yes.
You're very familiar with firearms, are you not?
Familiar.
In fact, one of your hobbies is you like to hunt.
Yes.
And you were a law enforcement officer, like you said, for 8 years.
Yes.
And you went under training every single year because you had to do an annual training, correct?
Yes.
And one of those things that every single year during that annual training they talk about is gun safety.
Yes.
And I know Mr. Taddy talked a little bit, like you said, when you're at the gun range, you guys are in a straight line.
Yes.
And in fact, there's a term called a hot range and a cold range. Is that correct?
Correct.
Hot range means that guns are being fired and nobody's allowed to go downrange. Is that correct?
Yes.
And a cold range means that people are going down to check targets, or people are in that area to where there's a risk, so you have to put all guns down and nobody can have a gun in their hand. Is that correct?
Correct.
And in fact, there's general rules of safety that you guys learn every year. Like, you always treat a firearm if it's loaded.
Correct.
And you never point it towards another person.
Correct.
And that you should not handle firearms, especially when drinking or intoxicated.
Yes.
And that you only point a firearm as something that you intend to kill or destroy.
That's correct.
I also want to talk about these trainings. When you do these trainings, you're shooting at targets, correct?
Yes.
And when you're shooting at these targets, you aim your firearm, get a clear sight picture,
Yes.
using your sights,
Yeah.
and then you pull that trigger.
Yes.
When you were sitting at that table with Paulina, there was a point in time you activated that red dot sight.
Yes.
In fact, you told Detective Kern it was to show her how that sight worked.
Yes.
Show her how to get a sight picture.
Yes.
Show her how to aim at a target.
Yes.
You heard the medical examiner's testimony yesterday that when that path of that bullet went directly in her forehead and directly out this back of her head.
Yeah.
Correct? So that means at the time that gun went off, it was aimed directly at her. No further questions, Judge.
Any redirect examination?
Just briefly. So, Mr. O'Neill asked you if you intended to pull the trigger.
I did.
Did you intend to shoot Paulina?
No.
Did you intend to discharge that weapon?
No.
You thought it was going to click. No further questions.
Any recross examination?
No, Your Honor.
Members of the jury, do any of you all have questions? If so, please raise your hands. Okay, write them down on a clean sheet of paper, please. Do we have one more coming? If so, raise your hand if you're still writing. Our juror there in the back row, I am having trouble reading your handwriting. It's the third word. I'm going to ask that you just clean it up for me. Council approach. Any other questions? If so, raise your hands. But we have. Okay. Yeah. Nice nod. Take what time you need. Write it. Take the time you need to think out how you want me to pose the question. No rush. Counsel, if y'all want to talk in the meantime and look at the others. Put the white noise on. Mr. Boileau, I'm going to ask you the questions that the jury has posed. I'm going to ask them exactly as they're written. Had he cleaned guns in front of Polina before the night in question?
No.
Were you standing or sitting when gun went off?
I believe I was sitting.
He stated drinks were 2 for 1, so they had 6 drinks instead of 3.
No, I bought 6 drinks total, 3 each.
Why was her hand in front of her face at time of accident?
I have no idea.
At some point, defendant said, forgot it was loaded. Now he says he knew it was loaded. Why the change?
I don't believe I ever said it. I knew it was loaded. I remember hindsight that I put it together the normal way I would put it away, and I forgot I did that.
What do you mean, I knew better and I shouldn't have let this happen?
I should have changed something to keep this from happening. Should have been sitting across from each other.
Aye. Defense, any follow-up?
No, sir.
State, any follow-up?
No, Your Honor.
Okay. Members of the jury, any additional questions from any of you all? If so, please raise your hands. Okay. Oh, go ahead. Whoa. Questions have to be written. Okay, and use a clean sheet of paper with no other writing on it. White noise on, ladies and gentlemen. Sir, the jury has posed an additional question. Are pointing guns at each other part of training?
No.
Any follow-up?
Yes.
State?
No, Your Honor.
members of the jury, any additional questions? If so, please raise your hand. Okay. Please write down on a clean piece of paper. Put the white noise on, ladies and gentlemen. Why did you decide to clean guns at the end of the day, especially since you had been drinking?
I thought we were being safe. I didn't really put much thought into it.
Any follow-up defense?
Yes, sir.
State.
No, Your Honor.
Members of the jury, any additional questions? If so, raise your hands. All right, seeing no hands, sir, you can retake your seat. Mr. Tiny, you can
Address.
state you intend to present any rebuttal evidence.
No, Your Honor.
All right, members of the jury, the state and the defense have both rested, which means that you've heard all the evidence that you're going to hear in this trial. At this point, we have to get the jury instructions together, the final instructions on the law that I'm going to give you. That may take a couple of minutes. There are some other things logistically that we have to handle. I will try to get you back in here by 9:45. It may take a little longer, maybe a little shorter, but take advantage of the break, have some coffee, water, stretch your legs, what have you. Your notepads must remain here in the courtroom face down. I want to remind you the case is not being submitted to you yet for deliberations, okay? So you cannot talk about the case with one another in any way, shape, or form, okay? Also, if you happen to get on your cell phones or other electronic devices during the break, do not use them to try to learn about the case or the persons or places involved in the case. The best practice would be not even to get on your phones and check it unless you're expecting some type of emergency message or something of that nature, okay? But we'll get you back in here as soon as we're able, okay? All right, leave your notepads here. We'll see you soon. The jury's left the courtroom. Counsel, y'all can be seated. Let's move into the final charge conference. Did either the state or defense see anything in the draft instructions that I sent you all yesterday at the close of the day that you believe warranted additional modification?
No, sir.
No, sir.
I know we agreed we would circle back on 3.10 rules for deliberation, number 7. The jury is not to discuss any questions that a juror wrote that were not asked by the court and must not hold that against either party. There were no questions posed by the jurors that were not asked, so I will remove that.
Yes, sir.
State defense, if you don't mind coming up and taking one last look at the draft that I'm going to photocopy for the jurors. I'll give them a copy to read along with while I read out loud. Also the separate verdict form. So it'll be a separate verdict form. So I give them a copy of the verdict form in the file. Yeah, so that's the copy they read along with that we're going to take up. Yes, that way they fill out that one, not the one in the packet. Yeah, it's okay. I don't mind to save paper moving the verdict form on that page. You all good with that? Save a 12 piece of paper. Yeah, I'll leave it as is. It's printed. Okay. All right. So we need 9 copies, one for each of the jurors. State, do you want a printed copy?
If you don't mind, yes, Your Honor.
Defense, would you like a printed copy?
Yes, sir.
Your Honor, while those are being printed, can I use the restroom one more time before we?
Yes, sir. We'll have a couple minutes.
I want to make sure that
But before you leave, Mr. O'Neill, Mr. Taddy, how long do you think you need for closing argument?
I wouldn't think any more than 45 minutes.
Okay. I won't. Fair enough. I won't put a time restriction on it. You all take whatever time you need.
Yes, Your Honor.
Judge told me one time I had 5 minutes for my rebuttal closing. And then in the 12th hour of the jury deliberation, he says, I probably should have let you do your closing.
Y'all have what time you need today. Counsel, I've emailed you also an electronic copy of the final instructions and verdict form if you're going to be incorporating that in a PowerPoint or what have you. Are you both using PowerPoint in closing?
Yes.
Yes.
Okay. Just let me know when you want me to engage the presentation screen, if you want that right at the outset, or if you want to wait a little bit. Okay. I'll be back in a few moments with the copies.
Thank you.
Is he going to the reason? Y'all can see it, I'm sorry. Those are for the jurors. Anything else before we bring in the jury for instructions and argument? State?
No.
Defense?
No.
Let's go ahead and bring them in. Counsel, y'all be seated. Thank you. Ladies and gentlemen, welcome back. So we're going to now begin with the instructions on the law, closing argument, and then final instructions. So the way this will work, I will read the bulk of the instructions that you're holding in your hand to you. The attorneys will make their arguments, then I'll conclude with some final instructions, and deliberations will begin. So what you're going to be bringing back into the jury room, okay, the draft of the instructions that you're holding in your hands, those don't go back with you. Okay? Those are simply for you to read along with while I read them out loud, hopefully to aid in understanding and comprehension. You will get a copy of the final instructions. Ones that I actually read from will go back with you to the jury deliberation room. I tell you that because if you end up wanting to take notes during your closing argument, do not take them on the copy of the instructions that you're holding in your hand, because we are going to take those up and destroy them. Okay, so any notes that you want to take during closing arguments or during the reading of the instructions, make sure you take them on your notepads. Okay? Again, these are just being provided for your convenience to help you follow along as I read them. Let's go ahead and start. We're going to begin on page 1. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Leslie Dale Boileau, the defendant junior, the defendant in this case, has been accused of the crime of manslaughter. Leslie Dale Boileau Jr. is accused of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Polina Wright was killed by Leslie Dale Boileau Jr., you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or whether the killing was excusable or resulted from the justifiable use of deadly force. The use of deadly force to kill a human being is justifiable homicide, and therefore lawful, if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. The killing of a human being is excusable, and therefore lawful, under any one of the following 3 circumstances. 1. When the killing is committed by accident and misfortune, in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Polina Wright is dead. 2. Leslie Dale Boileau Jr. A. intentionally committed an act or acts that caused the death of Polina Wright, or B. caused the death of Polina Wright by his culpable negligence. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict a manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or a grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. If you find that Leslie Dale Boileau Jr. committed manslaughter, you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Leslie Dale Boileau Jr. committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, or one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence whether the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1. Whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have an equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing arguments. Members of the jury, after the state and defense have both made their arguments, we will pick up on page 6 of 10 and conclude with the final instructions. State?
Yes, Your Honor, before I begin, if I can have access to these.
Yes, sir.
May it please the court, counsel, members of the jury.
That's the defense.
Is that the defense team?
There we go. Let me know when you're ready, Mr. Renner.
Should be up.
There we go. Perfect.
Intentional acts with unintended results. Quite simply put, that's why we're here today. That's manslaughter. As I stand before you today, and as Mr. Buxton told you yesterday in opening statements, and as I even discussed with you Monday at jury selection, this isn't a case where we're alleging or we're going to prove to you that Leslie Dale Boileau Jr. intended to kill Polina Wright, thought about killing Polina Wright, or killed her out of hatred, ill will, spite, or bad intent. However, what we did tell you we were going to prove, and what we did prove throughout yesterday and today, is that the defendant intentionally committed actions that led to the death of Polina Wright. As the judge has been reading instructions, and as he said, he's going to read some other instructions, one of the things that he's going to go over with you in a few minutes is a jury verdict form, and it's going to look a lot like this. Quite simply, there's two options. Either you find the defendant guilty of manslaughter, or you find him not guilty. And we're going to talk about why the state proved beyond a reasonable doubt that the defendant is guilty of manslaughter, and we'll talk about that in a couple minutes. But when you check A, there's an additional question, which is, did the state prove beyond a reasonable doubt that during the commission of the crime, the defendant personally carried, used, displayed, threatened to use, or attempted to use a firearm? And you have to check yes or no once you check A. So let's go through what exactly it is that I have to prove. And I know the judge just read it to you, but I kind of want to go through it a little bit more in detail. So to prove manslaughter, state has to prove the following two elements. Number one, Polina Wright is dead. Well, members of the jury, that part of your job for deliberations has already been done. You heard that there was a stipulated fact that the person who unfortunately lost their life on the night of September 19, 2024 was Polina Wright. You heard from the medical examiner that Polina Wright suffered a gunshot wound to the head, succumbed to those injuries, and unfortunately passed away. Element one is not in question. However, what you do have to determine is element two. That Leslie Dale Boileau Jr. either A, intentionally committed an act or acts that caused the death of Polina Wright, or caused the death of Polina Wright by his culpable negligence. So what does that mean? Well, as the judge read to you, in order to convict of manslaughter by act, it's not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Let's talk about that for a minute. We've heard several statements from the defendant throughout his 911 call, body-worn camera, statements to Detective Kern, and even when he sat here today on the jury stand and talked to us. What was the one consistent thing he said the entire time? I was holding the gun, I pulled the trigger. He didn't slip, he didn't fall, he didn't drop the gun, he didn't accidentally pick up the gun in a way where he grabbed the trigger and made it off. What he's consistently said the entire time was, we were doing dry fire exercises. What's a dry fire exercise? That's when we fire the gun when it's unloaded. You pull the trigger, you hear it go click, and then you have to reset the trigger. What's resetting the trigger? You have to charge it. Pull that charging rod back, let the trigger reset, and pull the trigger again. What was one of the first questions I asked the members of the jury when I got up here on cross-examination? So when you had that gun in your hand and it went off, you intentionally pulled the trigger. Yes, an intentional act. That's where our job is done. I don't have to prove that he intended for that gun to go off. I don't have to prove that he intended for that bullet to hit Polina Wright and for it to kill her. It's extremely unfortunate what happened that night. I'm not disagreeing with that. And I'm not disagreeing that this was unavoidable and other decisions could have been made to where we weren't here today. But unfortunately, no matter how anybody feels about the situation or how that went down last night, does not change the circumstances of the law, the facts, and what the law requires for me to prove, and for you guys when you go back to deliberate, what you have to decide whether we proved or not. Now, I know there was some other things that the defendant wanted to say on the stand to kind of explain how things happened. And members of the jury, I'm not one to say whether I believe or don't believe certain things. That's your job to determine a witness's credibility. But as the judge talked about, things that you get to talk about or consider when weighing a witness's credibility is whether it makes sense and whether it is consistent with the other evidence that we've seen and what we've heard. And I find it interesting today that when the defendant's on the stand, he's talking about how he's trying to manipulate this gun, and he's cradling it, but he's sitting and cradling it, and he's trying to cock it. You get to take that firearm into the jury room. You get to look at it. You saw Ms. Killinger yesterday standing in front of you displaying how that firearm works, how that firearm operates, what you have to do to charge that firearm. You have to pull that charging rod back and let it go. Cradling it, pulling it, it's not consistent with what happened. Holding it up to your head to hear if there's a click, but shooting Polina Wright dead center in the forehead, not consistent with what the evidence was showing us. What is consistent is what he told law enforcement, what he told the 911 operator, what he told Detective Kern, and what he kind of a little bit told us tonight, or today, dry fire exercises. We heard a little bit about that training. One of the first things we do as law enforcement is we do dry fire exercises, and one of those reasons why we do dry fire exercises is practicing how to acquire a sight picture, how to aim down a gun and get our target, how to see it. When we're at the gun range doing our trainings, we take those guns, we aim right at our target. Talked about the rules of gun safety. Never point a gun at something you don't intend to shoot or destroy. Never point a gun at another person. You always point the gun at your target. That's why the red dot sight was on that night. Dry fire exercises, training exercises, looking at your target. Members of the jury, there's signs outside this courthouse. You can't bring in guns, weapons. I'm hearing you can't even bring in metal cups now. But you know what you're not prohibited from bringing in here? Is your common sense. This wasn't a situation where the defendant was pointing the gun at a wall next to Polina Wright and the bullet curves and hits her dead center in the head, goes out the exact center of the back of her head, into the wall directly behind her. Clear shot that we even see in that photo. He intentionally aimed that gun at her. He intentionally pulled that trigger. He just did not intend for the outcome to happen. That, members of the jury, is why that's manslaughter. But let's talk, because there's an or in there. We've talked about intentional act a little bit, but there's that second one too. Culpable negligence. Culpable negligence, as I said, is every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or a grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of others, and culpable negligence is consciously doing an act or following the course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. Let's talk about that. What did he tell us today? The one thing that I should have changed, the one thing I know I did wrong, we shouldn't have been sitting across from each other. Because when we're sitting across from each other and I point a gun and I intentionally pull the trigger, it might go through the person's head and into the wall in the kitchen. Because when you're sitting across from each other, there's a chance that somebody's in the line of fire. That's why I asked those questions on cross too about hot ranges and cold ranges, something that the defendant is obviously very familiar with. That when you're at a gun range, anytime anybody crosses the imaginary line that you're sitting and firing those guns, that range goes cold. Meaning that everyone has to put the guns down and lay them down. Doesn't matter whether it's the person next to you or 5 rows down stepping out in front of that line. Because there's always a concern or fear that somebody could get hit with a bullet. This wasn't a situation where he had Polina Wright slightly to his side but slightly in front of her. She was dead in front of her, doing training exercises, pointing guns at each other. And I understand. He said it today. He said it a couple times during current. Well, it was at their general direction. But members of the jury, that's not the case. How else do we know that besides just with the evidence of the trajectory? The other thing we talked about, and specifically what Dr. Lange talked about, that injury to Polina Wright's finger. Now, I'll be the first person to tell you, I know Mr. Taddy will probably say the same thing. No, Dr. Lange cannot tell you in any way, shape, or form what Polina Wright was doing with her hand moments before she got shot. That's a question for you guys to determine and for you guys to figure out. However, based off the circumstances, the evidence and testimony been provided, I would submit that one way is that the defendant was pointing the gun at her, and a natural reaction by most people, don't point that at me. Hey, don't point at my face. Because we know where it was aiming. Hey, don't do that. The person being taught how to safely use, own, and operate firearms was the one that night who had the common sense to go, don't point it at my face. Not the person with the years of experience, the years of training, familiarity with firearms. Let's talk about that training. I entered in a packet yesterday of the defendant's training records. It's a pretty big packet, but I kind of want to highlight a couple pages of why it was important and why I wanted to introduce that. The first one is these are 2 pages. The first one on the left is his history from 2016 to 2020. Or I'm sorry, 2017 to 2020. The one on the right is 2020 to 2024. And what you see is the number of hours that he completes for certain titles or courses in that time frame for certain topics. On the one on the left for firearms, it's 21 hours. On the one on the right from 2020 to 2024, it's 24 and a half hours. Indicating in that 8 years that he's with law enforcement, he had over 44 hours of training, courses, classes on how to use, operate, and the general functioning of firearms. And he even told you today, not in any of those classes, trainings, studies, Do they suggest, do they tell you, do they have you point firearms at other people, point firearms at people with downrange, point guns even in general directions? Because that's not safe. And we talked about his training that he did every single year. 2017, 2018, 2019, 2020, 21, 22, 23, 24. And what you see at the top of all of those are rifle qualification courses. We actually kind of heard in a roundabout way a little bit about that yesterday with Detective Kern. When Mr. Taddy was asking him questions about rifles and how we heard him in the interview saying, I don't know much about Daniel defense guns. And Mr. Taddy asked him, is that true? And he said, I have very little familiarity with assault rifles. In fact, I'm not even issued an agency one. I don't do the training every year. But you know who did? Leslie Dale Boileau Jr. And what's one of the things that we see every single year about halfway through on those lists when it's passed? Safety. Meaning every single year when he has to go get requalified to use an assault rifle exactly like what he shot Polina Wright with, he has to go over how to safely handle and operate a firearm. He has to go over every single year what he told us today, which is you don't point guns at each other. You don't handle guns when you've been drinking or under the influence. You don't handle guns with distractions like loud TV with football in the background. You don't handle guns with somebody who doesn't know any experience. You don't point a gun at somebody if you're not intending to shoot them or destroy them. There's one thing the defendant said today on the stand when answering one of your questions that I think sums up very best what happened that night. And I'm sorry I forget the question that was asked to him. But the response he gave was, I didn't put much thought into it. That, members of the jury, is culpable negligence. Handling arguably one of the most deadly things on this planet with somebody who has little to no knowledge about it, pointing it at them, dry firing it, having live ammunition and loaded magazines on that table, playing with fire, picking up that gun, pointing it at a person, pulling the trigger, racking the gun, pulling the trigger again. And I kind of want to stop and circle on that for a minute. Because again, members of the jury, it's up for your interpretation to decide. But pay close attention to what he's talked about with Detective Kern and even kind of with his testimony, but that inconsistency. Because the way I recall it is he talks about how he was cleaning the rifle first. Polina was off doing other things. He was cleaning the rifle. She wanted to see parts. He's showing her parts, puts it back together. They start dry firing that rifle. They're done with it. He was going to put it away. She grabs the gun. He grabs the rifle again and loads it. But then when Mr. Taddy today asked him, well, how did the gun go off? Well, I had just put it back together, and I wanted to make sure it was operating, and I wanted to hear that click. So was it that you cleaned the gun, had dry fired it multiple times, heard the click every time, pulled the charging rod back every single time, hearing the gun and feeling that trigger reset, pulling it, and then forgot you put a loaded magazine in it? Or is it what we just heard for the first time today, that that gun had never been dry fired until he actually discharged it and shot Polina Wright? You get to make that determination. But members of the jury, at the end of it all, you don't even have to just take my word for it that it's culpable negligence. We heard it from the defendant multiple times throughout the 911 call, throughout the body-worn camera. I'm going to have you listen one more time.
God damn it, no! I knew we should have been doing this!
No! I knew we should have been fucking doing this! She has one. I don't know why we're fucking doing this!
I knew this was a I know it looks really fucking bad. But I know better. I know fucking better. Why the fuck was I doing... I should not have let this happen! Fucking let this happen! I know better!
I fucking know better. Should not have been fucking doing this.
Bicyclist is on the ground.
No, I know better. We should not have been doing that.
Which I know is fucking wrong. We should not have been doing that. She wasn't doing it properly because we were pointing the guns at each other. We were in our. I know better. That should not have been happening. Oh, it sounds bad, but after we go to dinner and have a few drinks, I get sloppy, I guess. I should not have been allowing that to happen.
That, members of the jury, is a negligent act or admission that was committed with an utter disregard for the safety of others. That's doing conduct that the defendant knew or reasonably should have known could have caused great bodily harm or death of Polina Wright, but did those actions anyways. That was one of the questions that you members of the jury asked the defendant on the stand. That's your answer. The defendant knew the potential outcome, the potential results, and he did it anyways. That, members of the jury, is culpable negligence. That, members of the jury, is why when you go back in that jury verdict room and you get that jury verdict form, you're going to find the defendant guilty. And you're going to find that during that act of manslaughter that he did actually possess a firearm. Because that's what the evidence supports, what justice demands, and what the law requires. Thank you.
Please, court.
Sure. Let me know when you're ready for me to switch it over to presentation.
Ready. Good morning. First off, on behalf of my client and myself, thank you. You paid attention. And you agreed to become a part of something that you don't come across every day of your life. Okay? Probably inconvenient. And I'm sure all of you would much rather be someplace else right now. And on top of that, we're going to ask you to make a really important decision. So thank you. I told you in my opening statement that everything that the police department and frankly prosecutors knew about what happened to Polina Wright came from what Dale said to them. But all they seemed to hear was we were pointing the guns at each other. A statement made minutes after the worst moment in his life, covered in his girlfriend's blood, while his head is swirling between grief, anger at himself, and disbelief for the situation he found himself in. A couple hours later, when Detective Kern went straight to that statement, Dale said, no, not pointing at each other, pointing in the general direction. And it's on the tape. Watch it. Okay? The pointing at each other thing should have died a quick death right there. Because he explained, no, that's not what we were doing. He has never, ever said we were pointing guns like this, aiming at each other. There is absolutely no evidence that that ever happened. But apparently, Detective Kern didn't hear the air come out of the balloon when Dale said no. We weren't pointing them at each other. They were in the general direction. Because obviously they're sitting across the table from each other. That suddenly didn't matter. No. Apparently the detective decided he knew all that he needed to know. Didn't matter what happened earlier that day. He told me that when I asked him if he knew what they had done all day. Didn't matter. Bet it would have mattered if Dale and Pauline had had some argument and he threatened her. But the detective didn't need to know that, apparently. It didn't matter what Dale and Paulina did for the 2.5 hours after they got home from the restaurant. He told me that too when I asked him. Do you know everything they did when they got home? I know enough. So obviously they weren't sitting there with those guns for 2.5 hours. That defies any logic. They were getting up, going to the bathroom, going to see the TV. There's a dog in the house, there's a cat in the house. But that didn't matter to Detective Kern. Didn't matter how much alcohol is in a $4.49 margarita. It didn't matter whether there was more alcohol in the house. Which is why he said he didn't ask the evidence technician to look for it. There wasn't, and you could see it in the pictures. Look at the picture of the dining room table. The only can on the table, the evidence technician identified as green tea. There's pictures of the kitchen, sink. There's no alcohol container anywhere out in the living area of the house. That wasn't important. But he kind of tricked himself because his explanation for not telling the tech to look for alcohol was, well, I talked to him and I didn't see any indication of a problem. Boom. So why are we talking about alcohol today? Why? Detective Kern didn't think it was a problem. And that is absolutely symptomatic of how the detective approached this case. He reached conclusions based on little nuggets of information, selective nuggets of information, and then decided there was no need to actually test or verify those conclusions when it could have been done so easily. Show me what you did. That's not a technical or hard question. Pretty easy. And when a guy says we were pointing the guns at each other and then says no in the general direction, how do you figure that out? Show me what you did. Did he ever ask him? No. Not once. Not one time. Because he'd already made up his mind. And that's why, ultimately, he never really bothered to find out the circumstances surrounding Polina's death. He shot him with a gun, and he should have known better because he was a cop. Right? And he tried to backtrack from that, but he sure wrote it in his report. He didn't bother to ask. But now you know what happened. Because in this room, with his freedom at stake, every question is worth asking. Even yours. And I used to hate jury questions. Just scared the crap out of me. But I am thrilled that you folks got to ask questions. Because you did what Kern did. And he is totally incapable of telling you what happened to Polina. Because he doesn't know. So at the point they sat down, having rested their case, you didn't know. All you knew is she was shot in the head. And you knew, because of listening to his anguish, that he was responsible for that. You knew that. But that doesn't make him guilty of manslaughter. And I'm going to talk about this in a minute, but the problem is that manslaughter is not a function of the consequence of someone's behavior. You look at what they did, not the result of what they did. There's nowhere in that instruction that tells you somebody's guilty of manslaughter by culpable negligence. Culpable negligence comes along when you do something really bad. No, it doesn't say that. It focuses on the conduct. Is what he did more than making a mistake? And we'll put the consequence over here for a minute. Okay? Keep that kind of in the back of your head. And we're going to go through that instruction. Mr. O'Neill went through it one time. I'll focus on what I think you need to see. But all the law comes from the judge. And you're going to have it, so you can read it. Everything I said in an opening statement that would be revealed by the evidence proved to be accurate. I didn't miss one thing. But only because I presented evidence and because I poked or prodded evidence out of their witnesses. The evidence bringers failed. Utterly failed. What happened to 25-year-old Polina Wright was a tragedy. It shouldn't have happened. It makes you angry. Makes me angry that a mistake took the life of a beautiful young woman. But you can't use anger. You gotta leave that one outside. And the judge is going to tell you that. The next instruction he's going to read to you says, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Okay? Is it wrong to be angry? Of course not. Of course not. But that doesn't make it a crime, because it makes you angry. And to illustrate that, let's take a step back. Think for just a minute. And for a moment, let's pretend there was no gun. Okay? Let's pretend that on the way home from the restaurant, Dale dropped his phone on the floorboard of the truck. And for a split second, he looked down and shifted his feet to see where the phone went and slightly turned the wheel. Truck ran off the road, hit a tree. Pauline is dead. Would you be any less angry about the tragedy of her death? No. But under those circumstances, what caused her death was something probably every one of us has done one time or another driving a car. Made a stupid decision. Does that make you guilty of a manslaughter under my little facts? No. That's the differentiation. Driving cars is dangerous, handling firearms is dangerous, and accidents can happen doing either one with devastating consequences. But the consequence is not what makes it a crime. And it is to the law that we must look to determine whether a crime was committed in this case. You've seen this. There are two elements. We know Pauline is dead. He knows it his every waking moment. So you got two ways to do it. Intentionally committed an act or acts that cause the death of Polina Wright. Or cause the death of Polina Wright by his culpable negligence. So what was the intentional act? Pulling the trigger? He said he didn't intend the weapon to be pointed at Pauline. The only question Mr. O'Neill extracted from him was confirmed that you intended to pull the trigger. He said yes, he was doing a function test. He wasn't doing a dry fire exercise. Those are two different things. The function test goes with the AR style rifle because of the way it's put together. The dry fire exercise is a basic firearms training technique. It's safe. And what he did with Paulina does not demonstrate someone who was completely mindless of being safe with firearms. He handed her the rifle, no ammunition here. All back by him. Handed her, she picks the handgun up and it's loaded. Cool. Let me stop what I'm doing. Got it out of the holster, cleared it out, put the stuff over by him. And you saw the picture of that. The magazine and the one live round that he pulled out of the chamber, right there by him, where she couldn't get it. So she wasn't going to hurt herself or anybody else with what he was showing her. Nothing reckless about that. So what now is the intentional act? Suddenly, a few minutes ago, it becomes intentionally pointing it at Paulina. And he did not prove that. There's no evidence of that in this case. The best I can get is yes, he meant to pull the trigger to finish his function test. He didn't intend for it to go off. He didn't intend for it to have been steered in the direction of Polina because he had turned and was looking at the television. He didn't intend any of that. But yes, he pulled the trigger. But you don't get to manslaughter that way. And it's kind of evident how it morphed from you intentionally pulled the trigger, yes, because that was the honest answer, to now suddenly he's guilty of intentionally pointing the weapon. He never said that. Never said that. And there's no evidence of it. And, you know, Mr. O'Neill's fascinations about what Mr. Boileau really meant when he was making his statement and inviting you to kind of fill in gaps, like where was her hand? The expert, Dr. Lang, said she couldn't tell you what she was doing with her hand. No way. Okay? But now suddenly, don't point that gun at me. Folks, if that had happened, she'd be alive. Because he'd look up, oh, damn. Whole thing. You wouldn't be here, I wouldn't be here. Dale would be driving his car on patrol. And who gets a gun, put it in their face, and goes like that? But it went into her finger, back of her finger, and out. She had a lot of hair. And Dr. Lang agreed. She could have been pushing the hair out of her face. Dale doesn't know what she was doing because he wasn't looking at her. And he certainly wasn't pointing the rifle at her. It ended up pointed at her. But it wasn't intentional. And he can't be convicted based on the evidence in this case, based on the argument that he intentionally pointed that rifle at her. There's no evidence of that. So let's bump down to culpable negligence then. Because I submit intentionally pulling the trigger, which is the only thing they proved, does not establish manslaughter in this case. And the instruction is going to tell you that. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence, period. It's not criminal. Without any conscious intention to harm. Has there been any evidence offered in this case to prove that Dale Boileau consciously intended to harm his girlfriend? And if there isn't any evidence of that, then stupid stays stupid. It's negligence. It's a mistake. And there are things we can do in this country when someone does something stupid that causes harm to other people. You sue them. But they can't be convicted of a crime or an accident. The defendant cannot be guilty of manslaughter by committing a merely negligent act. There you go. Now the instruction is telling you, oh, so under the circumstances of this case, pulling the trigger doesn't get him to manslaughter. That's why it had to morph into pointing the rifle. And then the judge is going to tell you, in order to convict of manslaughter by act, that's that first one, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent. And I submit to you, pulling the trigger under the circumstances explained to you was negligent. Here. It wasn't a heinous crime that Mr. O'Neill wants it to be. It's a horrible, horrible accident. Only an intent to commit an act that was not merely negligent. And then he's going to give you a longer definition. I will now define culpable negligence for you. So now we'll bump down to the or B, right? We finished with the act. They haven't proven that. Now let's talk about whether they've proven culpable negligence. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. It's the second time that he's going to read that to you. That must mean something. It's there twice. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or a grossly careless disregard for the safety and welfare of the public. Okay? Doesn't say anything about consequence. Let's focus on what he did. Is there any evidence that in introducing her to these firearms that he was reckless or careless? No. Everything he handed to her, he made safe. And, oh, but he's got all this training. And you don't train with bullets on the table. And he should have known better. He said that. Okay? And he should have. But the training presents an interesting issue. That much training with a firearm removes the fear. Okay? I've had some firearm training. They still scare the crap out of me. And you can make a mistake being scared. But when you've had as much training as Dale has had, unfortunately, you get confident that you know what you're doing. And that's a normal consequence of being good at something. Like a chef with a knife. How many of you have you seen with their hands all carved up because they cut themselves every couple of days? And there isn't another person on the face of the earth more qualified to use a knife than your average chef. But accidents happen. Like, you shouldn't cut something with a box cutter while holding the thing like this and pulling the box cutter toward you. That's pretty stupid. I did that 3 days ago. Accidents happen. And you don't decide whether the accident is culpable negligence by looking at the consequence. Nowhere in this instruction do you see that. It doesn't become a crime because something awful happened. You have to look at what they did and what was going on. Without any conscious intention to harm. Second time. And then I read that to you. Grossly careless disregard for the safety and welfare of the public. Nothing about what you heard Dale Boileau did meets that definition. Because then they have to ignore how he handled the weapons when he gave them to her. Right? They want to jump now to this thing where he pointed it at her and pulled the trigger. And there's no evidence to support that. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. Consciously. He said from jump, he didn't think the gun was loaded. He forgot. And because of the way he kept it, remember what he said, and he told Kern this too. When he puts his gun away, it's got an empty chamber and a loaded magazine. Right? So the function test, which is designed for the AR rifle, because of the complexity of the trigger mechanism, is you pull the trigger, hold it back. The hammer falls. It clicks. And you have to listen for it. They'll explain it. Make sure we got everything in position so the gun will work. And you're holding it back, and then you pull the charge handle out. And it's not spring loaded. It'll go out and it'll stay there. And then you release the trigger, which resets it. Gets all the parts in line so that it'll go again. And you push the rod in. And if you're doing a proper function test, there's no bullets anywhere around you. Okay? So when you pull the trigger the second time, it's going to happen. But unfortunately, this one grabbed around because he forgot that he already had it ready to put away. All right. So there's no evidence of any utter disregard for the safety of others, and there's no evidence that he followed a course of conduct that he knew or should have known was likely to cause death or great bodily injury. Did he mess up? Absolutely. We can't judge this because of what happened. That's the hard part for you folks. Because it's so easy to become enraged at the whole idea that she's dead. You have to look at what happened. And the only reason you know anything about what happened is because he told you. Nothing in the other evidence introduced by the state tells you anything. And every bit of it corroborated what Dale said. In this country, we tell our citizens something important. If you have an accusation to make it in court. where a group of jurors can bring their experience and common sense to weigh the evidence and apply the law. But how do we protect people from mistakes and unfair accusations? The law has a way. It's called the burden of proof. It is our demand as citizens that any accusation be proved beyond a reasonable doubt. And as the judge has already told you, proof beyond a reasonable doubt does not mean proof beyond all doubt. Okay? So they don't have to prove it beyond all doubt. But a reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, but one which wavers and vacillates, jumps back and forth, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That's why, when you come to your decision today, you don't have to guess or speculate or consider mere possibility. I have not asked you to do that. I have given you evidence of what happened to Polina Wright in the absence of the evidence from the state. If the state cannot prove there are no reasons to doubt, nothing that would give a person reason to pause, that would make one hesitate before finding my client guilty, then the jury must keep its promise. Live up to your oath and do what the law requires. In this case, as difficult as this is, as terrible as what happened is terrible, there is no evidence that my client is guilty of manslaughter. He made a mistake. He'd be the object of a wail of a lawsuit. But he's not guilty of a crime. Thank you.
Thank you, counsel. State.
Mr. Taddy wanted to give a hypothetical of the situation. I'll give you another hypothetical. Let's say Leslie Dale Boileau and Polina Wright went to the restaurant. Instead of 3 margaritas, Leslie had 10. Decided to get behind the wheel of a car, loses control of the car, crashes, Polina dies. It's DUI manslaughter. Some might call it an accident. Some might call it misfortune. He could be sued for that. Still a criminal act. The one thing I agree with Mr. Taddy, we're not focused on the outcome here. Nowhere in the jury instructions does it say that. In fact, I went over that. He's gone over that. What matters are the actions that led up to the death of Polina Wright. And where I disagree with Mr. Taddy is that intentional action of pulling the trigger is in fact enough to prove manslaughter. That intentional act of pulling a trigger of a loaded firearm pointed at somebody else is, bless you, an intentional act that is manslaughter. Bless you. I'm not saying that the only part of this that was a culpable negligent act was the part where the gun actually went off. No, members of the jury, the fact of the moment that he had Polina Wright sit across the table with him with live, real firearms with the capability of shooting a bullet, that was when it began. That was just the snowball waiting for disaster to strike. However, what my focus is on is what actually happened that caused the death. Culpably negligent is having firearms that you know have the ability to kill somebody and having somebody sit across from you and point them in their general direction. Mr. Taddy keeps saying there's no evidence, there's no proof that he was pointing out. Members of the jury, I don't think that anybody else could have walked a straighter line of the trajectory of that bullet, of how it left his gun, went through the front of her skull, went out the back of her skull, and you heard the medical examiner. Wasn't left to right, wasn't up to down, it was dead straight through her head. And there's a reason why I put that photo in of that chair. You see where that chair was positioned, and right about head high, what do we see in the wall? A bullet hole. That's not randomly holding a gun in her general direction. That's not looking down a sight, pointing at your target during training exercises like he initially said. But here we are a year later, and it's, well, now I was just resetting the trigger and making sure it was doing a functioning test. That's the first time I've heard those words ever come out of Dale Boileau's mouth. You get to go back, you get to listen to the body-worn cameras, the 911 calls, the interviews as much as you want. You're actually going to have an opportunity to have a TV back there and play those things. And I tried my best to get a lot of timestamps down. There's a couple I don't, so I apologize that some of these you might have to search a little bit, but I can kind of give you the general area. Towards the very beginning of the 911 call, I didn't know it was loaded, and I shot her. Exhibit 6, Officer LeBay's body-wear camera. Right when they had gotten out of the house and gotten over at the truck. What did you see happen? We were pointing them at each other, and mine went off. The interview that he had with Detective Kern at the 6-minute 24 mark. So you charged it talking about the gun. That was Detective Kern's question. The defendant's answer? Yeah. Kristen Killinger told you what the charge process looks like on a firearm. 6:35, Detective Kern. Or I'm sorry, not Detective Kern. 6:35, the defendant. I made sure her gun was unloaded. Obviously, I did not do that with mine. 20:55. When Detective Kern's in the middle of asking him about this resetting the trigger process, and he tells Detective Kern, yeah, I reset the trigger. Watch his motions. I reset the trigger. He starts to kind of do it and stops. He's not holding it down, acting like he's doing it. He's not. No, I reset the trigger. Exactly what we saw Chris Killinger do yesterday. 22:45, Detective Kern. When you were dry firing the rifle, were you standing up or were you sitting down? The defendant's response, we were sitting down. And there's some other times in there where Detective Kern's asking about that. Were you sitting down the whole time? Well, most of the time. We might have gotten up to hand stuff across the table, but other than that, we were sitting at the table. And honestly, members of the jury, most important, at the 24-minute, 50-second mark, Detective Kern. Dale, is there anything I haven't asked you about or we haven't talked about that you think is important for me to know about this? Nope. Pretty much covers it up in a nutshell. But now today, oh no, it was this whole different situation. It was a misunderstanding. Doesn't make sense, members of the jury. Let's talk about what we heard him say today about that firearm and the process of how he was handling it right before it went off. So first it's, he's sitting at a table that's probably about yay high, cradling the gun, trying to rack it, maneuver the gun, because he's trying to make sure the trigger's reset. You get to go back there. What movement do you have to reset it? He's not cradling the gun, he's not holding it. Oh, well, because when I was cradling it, it's down here, so that's why I didn't see the mag. But then, what does he say a couple minutes later? That mag goes in here, and I can't do it with a lock. You'll see, it sticks out. What did he say that was important? After he's allegedly cradling it. Oh, I held it up to my head to hear that click. Holding it up to your head, you don't see a magazine hanging down right here? You don't notice that? You're not trained when you're training to make sure guns aren't live, the guns are safe, the guns aren't going to shoot anybody. You don't notice the magazine sticking out 6 inches, 5 inches from your face? There's also disagreement between Mr. Taddy and I about the alcohol. I'm not saying it's the only factor. I'm not saying it's the main factor. What I'm saying is it plays a part. It absolutely matters that shortly before he decided to take that gun and start cleaning it, handling it with somebody who's untrained, he was trained. Mr. Taddy wants to talk about, well, we don't know how much alcohol was in the drinks. It might have not been that much. It was happy hour. They could have been watered down. The defendant said they just tasted like mix. I submit to you, members of the jury, that makes it even more negligent. Because what that then would suggest is that he had a clear mind, clear thought, and still did these actions anyways. His decision-making, his thought process wasn't then inhibited or inebriated by any way, shape, or form, because now he's apparently telling you, no, I was stone cold sober and could think clearly and straight. And yet, thinking clearly and straight, with all the training experience and with the knowledge I have, I still thought that it was a good idea to point guns at each other. The reason why the rules of gun safety are is that you never point a gun at another person or in their general direction is because that is inherently dangerous. Because that is likely to result in death. Because there's always that chance that the gun is not unloaded. Like Mr. Taddy said in regular definition of just negligence, it talks about how there's not an intention to kill. In the definition of culpable negligence, neither is there a mention that there has to be an intention to kill either. It elevates it from your basic duties of responsibilities towards care towards others by taking it to that next step of saying something that is just so gross. It almost just slaps you in the face of, wow, that is just absolutely something you do not do. That, members of the jury, is why we're here today. The other thing I want to circle back, talk about, is Mr. Taddy keeps talking about this other method, about holding the trigger, clicking, pulling back. To be honest with you, I still don't fully understand it. You heard from Kristen Killinger yesterday. Mr. Taddy actually tried to ask her about it. Oh, isn't this another way to do that gun? What was her response? Why would anybody ever do that? Because that's not a common, normal way to do it. It's not a safe way to do it. That's not a normal, functioning way to clear and charge that gun. Which is something that any gun owner or somebody who's extremely familiar with these types of guns would also know. It doesn't make sense. And quite frankly, members of the jury, if it doesn't make sense, it's nonsense. What does make sense is when you take his initial statement, when he's the most excited, when he hasn't had time to actually think about the potential consequences, and is more focused on actually getting aid for Polina Wright, and says what actually happened of, we were pointing guns at each other and mine went off. That we were doing dry fire exercises. Or what we heard him tell Detective or Sergeant Ceroli, we were fucking around with the guns. That's not somebody who's just gotten a little too confident or somebody who believes in their ability. That's somebody who got sloppy, as he said. That's somebody who knew the risk, didn't care, and did what he did anyways that evening. What happened that night was completely avoidable. And when something is that avoidable by all of those steps that the defendant decided to take and not stop at, is what makes it culpably negligent. And when it's culpably negligent, it's manslaughter. I want to end by saying, on page 6 of those jury instructions that the judge gave you, we haven't gotten there yet, but he's going to read them here when I sit down in a minute. It goes through some rules of deliberation, and Mr. Taddy read one of those for you. In fact, he read number 3, that the case cannot be decided for or against anyone because you feel sorry for anyone or angry at anyone. But I also want to touch on number 7. Your verdict should not be influenced by feelings of prejudice, bias, sympathy. Your verdict must be based on the evidence and the law contained in these instructions. You very well might go back there and feel horrible for Dale about what happened that evening. Again, I'm not saying that he intended to kill her that night, but he intended to pull that trigger. You decide whether he intended to point that gun at her or not. Again, I surmise, based off the evidence and testimony, it's very clear that gun was aimed at her. Wasn't fiddling it around, wasn't messing with it. Even if you stop away for a second, you think he was just waving it around carelessly and happened to go off and just hit her perfect straight. That's still negligence, members of the jury. That's still a disregard for somebody's safety. You can't worry either, members of the jury. Number 5, your duty is to determine that the defendant has been proven guilty or not in accord with the law. It's the judge's job to determine the proper sentence. I know it's hard. I know he didn't intend it. But members of the jury, I would even implore on you that if there comes a point in time that you find yourself back in the jury room going, man, I wonder what's going to happen to him. It means your verdict's already been reached. You can't think about that. The law doesn't allow you to think about that. That's the judge's job. He's been sitting here this entire time. He's been listening to the facts. He's been listening to the evidence. That's not for you to decide. Your only job back there, members of the jury, is to determine whether myself and Mr. Buxman carry the burden that the state requires and prove this case beyond an exclusion to every single reasonable doubt. I'm confident, members of the jury, that when you go back there, that's why you're going to reach that verdict. The evidence supports, the law allows, quite frankly, most importantly, what justice demands. You find the defendant, Leslie Dale Boileau Jr., guilty of manslaughter. And when you do, you also find that during the manslaughter, Leslie Dale Boileau did in fact have in his care, custody, possession, or control, or did use a firearm. And again, as Mr. Taddy said, thank you so much for your time and attention in this matter.
Members of the jury, we're going to pick up on page 6 of 10 at 3.10, Rules for Deliberation. I'll give you all a minute to find your place. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Now, you're going to have in your packet of instructions that I'm going to give you, you're going to have this copy of the verdict form. At the bottom, it's going to have page 8 of 10. That's not the one that I want you to fill out. This is simply going back. This is part of the packet that we photocopied for you. I have a separate verdict form for you. It's identical to what is in your packet, except on the bottom it says verdict instead of having State of Florida versus Leslie Dale Boileau, the case number, and the page 8 of 10. So fill out the word verdict at the bottom. Okay. The verdict form reads as follows. In the Circuit Court of the Fifth Judicial Circuit of the State of Florida, in and for Marion County, State of Florida versus Leslie Dale Boileau Jr., Defendant, case number 2024 CF 4124. Verdict. We, the jury, find as follows as to the defendant in this case. Check only one. A. The defendant is guilty of manslaughter. If you check A, you must answer the following question. Check yes or no. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally carried, displayed, used, threatened to use, or attempted to use a firearm? Yes or no. B, the defendant is not guilty. So again, you will check either A or B. If you check A, you then have to answer the following question, yes or no. Your agreement on that question also must be unanimous. Okay? So say we all dated this blank day of October 2025 with a signature line for the foreperson. Today is October 1st, 2025. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom, or perhaps back in the jury room. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room while you are deliberating. If you have them here in the courtroom with you, kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you have them back in the jury room, Deputy Boucher will come back with a box and he will collect all of your cell phones and electronic devices. That includes an Apple Watch or smartwatch if you have one of those. And he'll guard those while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever you think will help you in your deliberations. With the exception of ammunition, all of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine the ammunition, please request that in writing by sending me a note through the bailiff. I will then have the bailiff collect the firearms from you, and the ammunition will be sent back for your examination. When you have concluded your examination of the ammunition, please notify me by sending another note through the bailiff. The bailiff will then collect the ammunition and return the firearms to you. If you wish to examine any firearm with the cable lock removed, please notify me by sending a note through the bailiff. I will then have the bailiff remove the cable lock from any firearm you wish to examine. When you have concluded your examination, please notify me of this by sending another note through the bailiff. The bailiff will then place the cable lock back upon any firearm from which it was removed. All exhibits consisting of audio or video recordings have been placed onto a laptop computer that will be sent into the jury room when you are deliberating. The laptop is not connected to the internet or any computer network and has been set up for the sole purpose of playing the recordings that were admitted into evidence. For your convenience, each recording has been placed on the desktop screen of the laptop, entitled in accordance with the name of the party who admitted the exhibit and the exhibit number. To listen to or view a recording, double-click the file on the desktop and it will open in a media player. The laptop is connected to a television that is set up to mirror what is displayed on the laptop. This will allow you to listen to and view these recordings during your deliberations. If you have any difficulty accessing these recordings on the laptop, please notify me by sending a note through the bailiff. In closing, let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now, first thing we're going to do at this point, everybody take your copy of the read-along instructions and pass them down to the left. Deputy Boucher will collect them. Second, as you know, I told you on Monday that we overselect the number of jurors that we need in the event that jurors become ill or unable to serve for any reason. And in this case, we selected 3 alternate jurors to have in reserve in the event that you all were needed. Now, looking at you all, it appears to me everybody here is able to serve. Does anybody here feel they're not able to serve for some reason at this point? Seeing no hands. What we'll do now is we'll identify the 3 of you who have been serving as alternate jurors in the case and who will be excused. Madam Clerk, who are our alternate jurors? Three of you have been serving as our alternate jurors. You have my thanks for your service. We never know in what cases we will need alternate jurors or how many will we need, so we always do overselect to make sure that we are able to have a full jury go back and deliberate. Do the 3 of you have any personal property back in the jury room? Yes. Okay. In a moment, I'm going to have you go back and get that. You all go back together. Okay. Get your personal property. My judicial assistant will meet you out in the hallway here, and she'll bring you back to my lobby. I have some juror certificates for you, and some thanks on jury service. Now, the remaining 6 of you, okay, you are the jury that will be deliberating in this case. You can bring your notes back with you while you deliberate. Alternates, please leave your notes on the chair. We'll collect those and we'll shred them here in a moment. When you all go back to deliberate, you cannot begin your deliberations until such time as the alternate jurors have left the room, and it's only the 6 of you in the room. Okay, Corporal Boucher or Deputy Boucher will turn the TV on back there for you and have the laptop queued up. Also, all the exhibits, as I indicated, are going to be sent back with you, and we're going to send back a copy of the verdict form as well as the draft or the instructions that I read to you. Okay. All right, so with that being said, go back, gather your electronic devices up for Corporal Boucher. Alternates, I'll see you in a few moments, and we'll await your knock. Counsel, if you all, for the record, the jury has left the courtroom. Can you all look at the exhibits, make sure everything's in order?
Yes, sir. Just your final, the magazines going back.
Yes, magazines can go back. The live rounds, I believe, which would be exhibits 11, 13, 15, 16, 17. 11, 13, 15, 16, 17. 13, 15, 16, 17. Deputy Boucher, is there any biohazard label on the Glock box?
There should be.
Okay.
There's
No, don't, no additional speaking about it. Yeah, just, I imagine they would recollect that there was blood on it and will handle it appropriately.
And Your
They
Honor,
have gloves back there.
for the record, there is a biohazard sticker on the rifle too. I don't recall though there being anything on it, but
Oh,
just to draw that to the court's attention.
yeah, they have gloves back there. They saw you all using gloves anytime you handled evidence. I trust they
Yes, Your Honor.
model. How is it? How is it now? That's fine. Just so it doesn't hurt somebody. Yeah. Yeah, that's it. Okay. Is that Exhibit A, videos, on call? Those can all go back too. That there's a DVD drive attached to the laptop. This way, if they have any trouble getting it on the computer, maybe they use those.
I tested all 5 and they played fine. I confirmed with Mr. Taddy, what I did is I labeled them, for instance, state 1-911 call, state 3, McCurdy body camera, those kind of things.
We'll be in recess here in a moment. State Defense, I trust that you have contact information for family and folks in the audience. If you need to reach them, and then obviously the clerk has your contact information.
Yes, sir.
Mr. Taddy, the clerk has your contact information. Are you staying or going back to your office?
Stay for a while. If I leave, I'll give her some numbers.
Okay. All right, very good. All right, well, we will await a verdict or a question.
Yes, Your Honor.
I will be in recess.
Leaving real fast.
What's that?
I said that's why I'm not leaving quickly, because I'm expecting many knocks at the door.
There may be. So, time will tell. We'll see you all shortly. Magnifying glass in the jury room after they requested one. So with that being said, I have a measuring device that unfolds. It's belonged to my grandfather once upon a time, and it's probably older than everything in this room, but I'm happy to let the jury use it if there's no objection from the state or defense.
No objection from the state, Your Honor.
No objection.
Okay. Folds out to 6 feet. So, very good. All right, we'll go ahead and bring the jury back in. Counsel, you all can be seated. Members of the jury, we received your question and your request, so I'm going to go ahead and I talked with the lawyers about it. And, I'm prepared to answer both the question and the request. You wrote a question, height of both Paula and Dale. the testimony in the case from Dr. Lang was that Ms. Wright was 5 foot 6 inches tall. Mr. Boileau testified that he was 5 foot 6 inches tall. Now, you also said, can we have a tape measure? So, I have this device here. It unfolds one at a time, up to 6 feet. You can have this. It's old. It belonged to my grandfather. It's a little keepsake I have in my family. We hand down tools from generation to generation. So please don't break it. Okay. But go easy on it, but you have this to use as you see fit, and you can retire and continue your deliberations. State of defense, juries of the court, any objection as to the answer and the delivery of the ruler?
No, Your Honor.
Okay. We'll be in recess again, and we'll await a knock. And state, so you're aware they got lunch at right about noon, so
Okay.
I know we all try to read the tea leaves as to how long they're going to take, so make of that what you will.
Yes, sir.
All right, thank you. I understand that the jury has reached a verdict. So before we bring them in, I do want to say to everybody here, families in attendance, obviously, you all have a interest in the outcome of this case. I want to commend all of you for how you've behaved during the course of the trial. I said it earlier today, and I'll say it again. I don't think I've ever been a part of a trial where we've had this many people here on a matter that's obviously close to all of you, where everybody has behaved appropriately. I trust that that will continue with the reading of the jury's verdict. I would ask that you show no visible signs of approval or disapproval of the verdict whatsoever, out of respect for the hard work that this jury has put into the case and for the difficult decision that we have called upon them to make. This is not their usual day-to-day existence. This is something extraordinary we have required of them. So, with that being said, are we ready to receive the jury?
Yes, Your Honor.
Yes, sir.
Okay. Counsel, you all can be seated. Ladies and gentlemen, welcome back. Ma'am, I trust you're the foreperson?
Yes.
You hand the verdict form to the bailiff, please. Has the jury reached a verdict?
Yes.
Okay. Mr. Boileau, will you please stand for the reading of the verdict? Madam Clerk.
Verdict, we the jury find as follows as the defendant in this case. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt of during the commission of the offense the defendant personally carried, displayed, used, threatened to use, or attempted to use a firearm? Yes. So say we all, day this first day of October 2025.
Okay, thank you. You all can be seated. Madam Clerk, will you please poll the jury? Members of the jury, the clerk will ask each of you individually whether this is your verdict. You respond with yes or no.
Linda Young, is this your verdict? Yes. Deborah Green, is this your verdict?
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege to not speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to each of you to decide whether to preserve your privacy as a juror. With that said, I hereby discharge you as the jury of this case. I do want to thank you sincerely for the time and attention you gave to this matter. If you'll retire once more to the jury room, Deputy Boucher will hand your cell phones out. I also have some juror certificates I will come back and give you as thanks for your jury service. I'll be with you shortly.
Thank you.
The jury has left the courtroom. Mr. Boileau will be remanded into custody.
The court consider allowing him to remain at liberty pending sentence.
No, sir. Now, let's talk about sentencing. He's entitled to a pre-sentence investigation. So one will be ordered. I would like that back from the Department of Corrections within 30 days. Now, how long? I see a lot of people here. I don't know how many people are going to want to speak at sentencing. How long do you all think we will need for a sentencing hearing?
I would imagine maybe at least an afternoon, Your Honor. If the court would allow, I can also kind of, if your assistant could provide a couple dates outside of that, I can obviously work with what works with the family and kind of have a better idea of how many statements to have a better idea of what time we would need.
Okay. All right. Well, as part of the pre-sentence investigation, people are free to write letters.
Yes, sir.
And for the state and the defense. I anticipate that I will probably do more reflecting on what sentence will be imposed than in most cases. I would appreciate as much information as I can have from both the state and the defense with the pre-sentence investigation. I will not send, I want at least 2 weeks after I have the PSI back to reflect on what's in it before we have a hearing.
Yes, Your Honor.
So, an afternoon, how long do you think you would need, Mr. Caddy, for what evidence you expect to present?
Probably a similar amount of time.
Okay. All right. Let's do this then. I ordinarily set a sentencing date today, after verdict. I will, Madam Clerk, for calendaring purposes, I'd like to put Mr. Boileau's case on my October, I think, 14th pretrial conference docket. Is that a Tuesday?
It is a Tuesday.
Okay. For calendaring, just so we have another date out in the future, he'll be put on that date. By then, I'll have my assistant reach out to you all with possible dates for sentencing, and we can schedule it accordingly. Do you all think you'll need, between the two of you, a day, or afternoon each, or you all think an afternoon or a morning total will be sufficient?
I think a day.
Maybe a day, Your Honor, if you want to kind of give us the availability this afternoon, even as soon as that, I can kind of talk to the family, maybe have an idea, so when Ms. Zeke reaches out, I can give a better idea.
Okay. Let's do this, Madam Clerk. Let's put him down on my November. Do you have my calendar? November 18th, 1 o'clock for pretrial conference. The PSI should be back by November the 1st. Between now and then, we'll figure out a day. I don't know with my trial schedule
Sure.
where we'll end up. We're probably looking, so that everybody here has an idea, probably mid to late November at the earliest, possibly even into December, but well, I'll try not to put it around the holidays if I can, but
Just trying.
very good. All right. Well, I'll see you all back in a couple weeks. Anything else to take up before we adjourn?
Nothing from the state, Your Honor.
No.
Okay. All right, very good.